protected conversation is a confidential, off-the-record discussion between an employer and an employee concerning settling of a dispute. Very often it results in the termination of employment, but it doesn't always have to. This area of law is governed by Section 111A of the Employment Rights Act 1996. It only applies to what's known as ordinary unfair dismissals, which are the 5 main dismissal reasons that you can use to terminate an employee's employment. You have to be careful not to operate in a way that causes improper behaviour during the process. If you do, then the discussions that you have with the employee can be brought to the attention of the employment tribunal. Unlike the without prejudice principle, there is no need for a dispute to be in place for these types of discussions to take place. As I said, it's important to avoid improper behaviour. Improper behaviour could be undue duress that is put on the employee to accept the discussion that you're proposing. What normally happens in this type of process is that either the employee or the employer will approach each other with a view to having this type of discussion so that they can bring the employee's employment to an end or settle a dispute between them. Once a proposal is made, then the employee has to have a reasonable period to consider it, and that's laid down by the ACAS Code of Practice in relation to settlement agreements. The minimum period to allow the employee to consider the proposal is 10 days. A settlement agreement is an agreement that an employer and an employee can enter into to record the terms that they've reached by way of agreement concerning the termination of an employee's employment. It doesn't always apply to a termination of employment. It could, for example, be an agreement that they sign which provides for a payment to the employee in circumstances where there may have been a dispute but the employee remains employed. Agreements are governed by Section 203 of the Employment Rights Act, which sets out exactly what the agreement needs to include. For example, it has to be in writing, it has to say that it complies with the necessary statutes, and it has to provide for the employee to have independent legal advice. It also needs to actually state who the advisor is, and whoever's advising the employee must have the appropriate insurance in place for the advice that is given. These agreements tend to be used upon termination of employment because it enables the parties to have a clean break of the employment relationship. The employee will sign the agreement in full and final settlement of claims that it has against the employer. These agreements are also used because they can be very tax efficient. Up to £30,000 can be taken by the employee under the terms of the settlement agreement. The agreement also normally includes provisions such as confidentiality agreements, which say that the employee will not discuss the terms of the agreement or the package that may have been offered to them. They often also include other provisions, such as an agreement that the parties won't make derogatory comments about each other. Now, given that there's a need to have independent legal advice on the agreement for it to be legally binding, very often the company will contribute towards the employee's legal fees. However, this is not a statutory requirement. Most companies will offer to contribute because they will have the benefit of the employee reaching an agreement in which a clean break has been effected. Whilst there is to a certain extent a clean break, there are some claims that cannot be compromised under a settlement agreement, and those relate to latent personal injury, accrued pension rights, and of course the employee's right to enforce the agreement if, for example, the company did not pay them. These agreements are very useful as it enables the parties to reach an agreement and move forward knowing that the company does not risk the employee being able to pursue claims against them. When you're contemplating making employees redundant, then there are 2 legal requirements that you need to meet. Firstly, you need to be able to establish that there is a genuine redundancy situation, and secondly, you have to follow a fair process. Turning to the first requirement, Section 139 of the Employment Rights Act 1996 sets out what the definition of a redundancy is. Definition of redundancy relates to either closure of a business, closure of a workplace, or where there is a diminished need for employees to carry out work of a particular kind. Aside of establishing that there is a genuine redundancy situation, as I said, it's also important that you follow the correct process. That involves you undertaking consultation with the employees. If you're contemplating making less than 20 employees redundant, then you have to undertake reasonable consultation. If you're contemplating making redundant between 20 and 99 employees, then as a minimum, you must provide for 30 days of consultation. If you're contemplating making in excess of 100 employees redundant, then you must consult for a minimum of 45 days. Consultation is designed to be two-way and is designed to provide the parties with an opportunity to try and find a way to avoid the redundancy or mitigate its effects. If you're required to undertake collective consultation, which applies if you're making redundant more than 20 employees, then you can consult with either unions or employee representatives that are appointed by the employees. Mitigating the effects of the redundancy might include you looking at whether there's suitable alternative employment that the employees can carry out, or other ways that you may be able to avoid the redundancy. Ultimately, if the employee is made redundant, then you need to consider making the payments that they're entitled to, which includes a statutory redundancy payment, payment of notice under their contract, and payment of any other sums that they may be due, for example, for accrued holiday. In terms of the statutory redundancy payment, this is calculated using a statutory formula based on their length of service, their age, and also their weekly pay. Well, before an employee can issue a tribunal claim, the first step that they have to take is to commence what's known as pre-claim conciliation via ACAS. This is a mandatory process which the employee has to commence before they can proceed with the claim in the employment tribunal. What they have to do is to register their potential claim with ACAS, and there is a 6-week statutory period that applies to allow the parties to try and reach a settlement concerning the employee's claims. In the event that a settlement can be reached, then the employee will sign what's known as a COT3 agreement. If settlement cannot be reached, then ACAS will issue a certificate which will have a specific number on it, which then allows the employee to register a complaint in the employment tribunal. When the employee registers their complaint, a copy of it is sent to the company. The company then has 28 days to respond. One of the first things that the employee must do, of course, is to ensure that their claim is issued within time. That provides that their claim must be issued within 3 months less 1 day of, for example, the date that their employment terminated. The timeline for them to issue the claim can be extended depending on when they trigger pre-claim conciliation. Once the company has responded to the claim by filing their grounds of resistance, which is really their defence to the claim, then the tribunal will set to provide directions for the parties to conduct the proceedings. That will include, for example, having a case management hearing where the judge may lay down some orders that the parties have to comply with to prepare for the hearing. That might include the employee providing a schedule of loss, disclosure, dealing with witness statements, and other administrative matters that the tribunal say the parties have to comply with. Ultimately, the tribunal will list the matter for a final hearing, at which witnesses will need to give evidence and submissions will be made. After the hearing, the tribunal will issue its remedy. That may include compensation, but also reinstatement or re-engagement. Reinstatement is where the employee is reinstated into their old job. Re-engagement is where they're allowed to return to the company but in alternative employment. In most circumstances, compensation is awarded by the tribunal rather than reinstatement or re-engagement. To avoid claims of unfair dismissal, firstly, you need to contemplate whether the reason that you're dismissing the employee falls within one of the 5 fair reasons. Those reasons are enshrined in Section 98 of the Employment Rights Act. Fair reasons for terminating an employee's employment are conduct or misconduct, as the case may be, capability and performance, statutory illegality, redundancy, and some other substantial reason. Looking at those in turn, misconduct is very often the reason why a lot of employees' employment is terminated. if an employee behaves in a way which is unacceptable to the company, then it may give the company grounds to discipline or dismiss the employee. Where it is misconduct, then the company must consider warning the employee before they're able to consider dismissing. If there is an issue of gross misconduct, then it can provide the company with the opportunity to terminate the employee's employment immediately and without the need to have warned the employee. It's important, however, that the correct process is followed when you're considering dismissing an employee for misconduct. As a minimum, the process must comply with the ACAS Code of Practice, and if you fail to follow that and the employee pursues a tribunal claim successfully, then their compensation can be uplifted as a result. Turning now to capability and performance. Capability can arise where the employee is unable to fulfil their duties due to ill health, or where they're not performing to the standard required. That first requirement, where for example there's an ill health issue, the company must follow a fair process by consulting with the employee, seeking independent medical advice, and considering things like reasonable adjustments if, for example, the individual has a disability, or suitable alternative employment. If those have not been considered, then the dismissal may be potentially unfair. In addition, with respect to performance, unless there is a gross negligence issue, which is unlikely, then the company would be expected to have at least warned the employee of the risk of dismissal if they did not improve their performance. The company also has to act reasonably by setting reasonable targets and allowing the individual a reasonable time frame to improve their performance. Statutory illegality applies to situations, for example, where an individual who's required to drive may have lost their driving licence, and for them to carry out their role, it would be illegal. Moving on to redundancy, where you're contemplating making an employee redundant, you have to be able to establish that there is a genuine redundancy situation, and that may include a closure of the business, a closure of the workplace where the employee is employed, or where there is a diminished need for the employee to carry out work of a particular kind. It's also imperative to avoid a finding of unfair dismissal, that the correct process is followed to consult with the employee and seek to identify ways of avoiding the redundancy. Depending on the number of employees who are affected, you may need to consider reasonable or collective consultation. Finally, turning to some of the substantial reason. This is the catch-all, widely defined category that allows you to consider terminating an employee's employment fairly, where it does not fit into the other fair reasons for dismissal. This reason can be used, for example, where there is a significant breakdown in relations, or where, for example, a third-party company, such as a client, has refused to allow the employee to continue to work on their premises, and you have no other work for them to carry out. It's important that you're able to establish that any dismissal fits within these 5 fair reasons. Otherwise, if you fail to do so and subsequently fail to follow the correct process, then it's likely an employee will be able to pursue a successful unfair dismissal claim.